So, ladies and gentlemen, with that, we move on to the next session titled Family Business Staying Together or Preying on Each Other. Just when the going looks good, a family dispute sets the company back. Is keeping the family aligned a precondition for sustained performance? Our panelists are Mr. Homi Khusrokhan. He has been the managing director of Tata Tea and Tata Chemicals, both of which became the world's second largest companies in tea and soda ash respectively during his tenure. By virtue of major international acquisitions which he managed successfully, prior to that he worked for 29 years with Glaxo and Burroughs Wellcome in India, from where he retired as the managing director. And during his stewardship in 1999, Glaxo was rated as India's most respected company across all industries. After retiring from Tata Group, he was appointed Special Advisor to the government-appointed Board of Satyam Computer Services Limited in 2009, post the fraud. He is presently Chairman of the Indian Red Cross Society and serves on the board of several trusts in the education and health sector. Additionally, he is a Senior Advisor, Private Equity to Tata Capital and serves on boards. Ladies and gentlemen, Mr. Khusrokhan. Our next panelist is Mr. Mukesh Butani. He is the founder and managing partner of BMR Legal Advocates and a member of Global Supervisory Board for the International Fiscal Association. He is a specialist in matters relating to trade and investment policy, business reorganizations, cross-border tax structuring, and corporate international tax with over 30 years of experience. He has several publications to his credit on transfer pricing, tax disputes resolution, and business restructuring, and also a dispute resolution mechanism in Asia. He has been a member of several high-powered committees set up by the Government of India and is regularly engaged with agencies such as Prime Minister's Economic Advisory Council and Niti Aayog on public policy matters. He has appeared in the Supreme Court of India and several high courts and has deposed as expert witness before foreign arbitral tribunals and courts. Ladies and gentlemen, Mr. Butani. Our next panelist is Dr. Shardul S. Shroff. He is the founder and executive chairman of Shardul, Amarchand, Mangaldas and Company. His over 45 years of experience spans across a wide spectrum of law, including M&A, financial regulatory practice, IBC, commercial litigation and arbitration, capital markets, disinvestments, and banking and finance. He is responsible for all new practices at the firm like ESG, artificial intelligence, TMT, etc. He has been a key member of a number of committees set up by the Government of India, including those relating to insolvency law and company law. He is a member of IBBI Expert Committee, which has been set up to propose a detailed framework for use of mediation under the IBC. His leadership role in innovation in legal practice has been a defining attribute. Ladies and gentlemen, Dr. Shroff. And our moderator for the session is going to be Mr. Butani. Over to you.
Thank you. Good afternoon, everyone. Thank you, Mr. Damodaran, for thinking of me to moderate this session. I must confess that the organizers have a knack for putting out a theme for every session, which is, kind of hitting below the belt, provocation to some extent. Family business, staying together or preying on each other. I don't know how I qualify to moderate this session, but nevertheless, let me try it. But I have two panelists over here who are iconic personalities in their own way. Dr. Shardul Shroff, iconic in my profession, the legal profession. He doesn't need any introduction. And Homi, who is presided over several boards in the Tata Group. Given the nature of the topic, we chose that we are not going to get into any names, but essentially give a flavor from a governance and also a legal standpoint as to what are the current challenges I see in the Indian landscape. So we wanted to examine the complex dynamics of the family-owned business because some of them thrive across generations while others fall prey to what I call it as conflict, and most of this conflict is internal conflict and not external conflict. So drawing from some of the Indian and global case studies, we wanted to assess some of the structural deficiency as we see based on case studies in India, legal aspects and governance challenges to ensure that the Indian businesses grow with a measure of stability. And the reason I say that is because I was very inspired by a couple of case studies and research that was put out by organizations like McKinsey and Barclays. In fact, I was surprised to see the Barclays 2025 study specifically on family-owned businesses in India. So just to give you an indication, the McKinsey case study on family-owned businesses identified, and the methodology was different in each of these studies, they identified 300 family-owned businesses in India, and they traced the contribution of these family-owned businesses to the GDP of the country. Figures are debatable whether they contribute 60% or 75%, depending on the measurement criteria you look at it. And the broad measurement criteria was whether the family-owned business is listed or unlisted. Because if you look at unlisted, the contribution is much bigger. These are the top 300 families. And the 300 that McKinsey chose in their study were all listed companies. The Barclays study, in fact, tries to address a very important perception, what happens in the third generation. So there is a myth prevalent because of a Harvard Business Review study that the third generation does not survive. And the common say is that the first generation builds the business, the second generation grows, and the third generation destroys. Unfortunately, when this became popular, both McKinsey and Barclays went into the details of these findings, and the findings were that they chose a sample of 100 companies in Chicago focusing only on manufacturing. And from there, this whole three-generation theory came up together. We'll look at some of those aspects as well. But I just thought before we get into the conversation, I would share with you a very important family-owned business case study which has attracted global headlines. This is the Murdoch family, or the family that ran the Fox, or still runs, the Fox Studios and the News Corp businesses. Interestingly, Mr. Murdoch, the founder, had 3 marriages, and he had kids from all the 3 marriages. The third marriage, from where he had kids, were born after he settled what he called it as a trust in 1999. And the trust in 1999 gave equal voting rights to all his 4 children, 2 each from the first and the second marriage, and gave non-voting rights subsequently to his kids from the third marriage. And in 2023, Mr. Murdoch decided that he is going to change the voting pattern in the trust such that one of his sons from the second marriage gets more rights than the other 3 children. The other 3 children disputed that, and a family dispute arose as a result of that. This family dispute was, battled in the court of state of Nevada, and the state of Nevada said that Mr. Murdoch actually acted in bad faith, and this was just a charade that was made out. Interestingly, the dispute arose because Mr. Murdoch, who wanted to give the right to one of his sons, they were on one side on the editorial content of Fox News. The other three children were on the other side, and the editorial content was in relation to right-wing politics. And we know that when the US government came up, and new government administration came up in 2024, media had a very important role to play in the elections in the US. Anyways, after he lost the battle in the Nevada court, he thought that in the interest of shareholders, he should not litigate any further, and he settled it. The settlement actually went again in favor of the son. He wanted to give the control, but the other three children got a little over $1 billion as settlement. There are some learnings from those situations. I just thought I'll introduce that as a case study and give Dr. Shroff the first right to be able to comment on what his experiences have been with regard to family settlement, family disputes, and then we will come to Homi from a corporate governance standpoint as to what his experiences are. Over to you.
So I think the first premise in relation to family settlements flows from a very important judgment where the courts have pronounced that the shareholder's property is distinct from the corporate property. What is meant is that a shareholder has his own separate property, his own separate assessment, and is a person distinct from the company. That's the fundamental rule which is evident in all family settlements. What has happened is that promoters have converted their privately made properties into corporate corpus and built on that. So in the process of shifting their individual property into companies, they have converted private property into public property. They have changed the character of their corpus, and when it gets embedded or part of the corporate enterprise, they raise capital and they effectively become part owners along with others so that there is no right to that property. They have effectively built public trust and public enterprise around that initial capital of the individual. Now, when you look at a family settlement, you are essentially dividing undertakings. You are not dividing assets, because an asset has no balance sheet. The very concept of a merger or a demerger or a spin-off all proceed on the basis that it is undertakings which have balance sheets, and as part of the SEBI disclosure rules, you have to publish undertaking balance sheets so that you reflect year on year, quarter on quarter profits. So if the balance sheet and the presentation to the members of the public does not disclose separate undertakings, you can't develop an undertaking on the eve of a settlement. Because then you are creating an artificial being around the principle of either the business undertaking which runs a particular business or around an asset which is unique. So for example, people have built their houses around, put them in the company. People have brought in several types of undertakings which are typically not corporate property, but for purposes of taxation, purposes of a wide variety of reasons, they've gone into the company. Now, when they separate, they want those assets back.
Sorry, go ahead.
So this is the background within which you are looking at it. The fundamental principle of our courts is that if a family settlement comes before it, even if it is slightly at variance with the law, it will be enforced. That's the rule. So you go out of the way to support a family settlement because you don't want the company to be in litigation and destroying shareholder value. That is the fundamental principle in settlements. You see that in the case of Murdoch, because he has taken that decision in the interest of the shareholders. He had a dispute in relation to the first round, and he came out of that as having done that process in bad faith, so it was effectively thrown back at him, and he had to rework separate rules. So in the second round, he settled more money on his disputing children, but he still continued with the disproportionate rights that he gave to the middle families, James Murdoch, effectively. So he acted in the best interest of the company, and he enhanced shareholder value by virtue of giving the company to the person who can manage it. That's the rule which has been adopted. Then, of course, there are different principles which get invoked in the Indian context, but I'm not commenting on that at this time.
Sure. Dr. Shroff, before we go to Homi, there have been many instances in the Indian corporate framework where disputes have arisen, and I just wanted your view. So it's one thing to say a family company continues to operate after one's death of the patriarch, and you also answered the question in the context of can a patriarch bequeath corporate assets through a will? Many questions have arisen. Do these wills now made to be known or brought to the attention of the regulator from a corporate governance standpoint? There are also questions that are arising on legal enforceability of such private settlements that occur between the families and whether, from a corporate governance standpoint, they should be brought to the notice of the shareholder. We also saw recently a fifth generation business who, because of the current constraints under the SEBI law, had to comply with the open offer takeover code requirements. I wanted to get your expert view also on this principle that the Supreme Court many years back enshrined in the famous Ranganath Reddy case. And just for everyone's knowledge, this case identifies that the principal purpose of a family settlement is to protect the interest of the family members and as such provide a broad interpretation. Now, this was at a time when most family businesses were not listed companies. But this principle holds good today as well. I wanted to get expert view from Dr. Shroff if this is a good law or does it stifle the arms of the judiciary?
I think there is another case which you must refer to in the context of the case that you just mentioned. There is a rule which was enunciated by Justice Sawant in the Supreme Court, which is in the case of V.B. Rangaraj, wherein effectively what was done on the principles of doctrine of notice is that those private settlements which were worked among by members of the family, if they are not embedded in the articles of association, they are not binding on the company. They may be binding inter se the family members, but they don't bind the company. Now that threw up a separate practice among legal professionals of India that you must therefore embed in the articles everything including the kitchen sink. That was the expression used among lawyers, that you bring in everything. So you give a notice to the public that these are the rules within this family group which bind them. Now, in a will or in a succession plan, what happens is when the patriarch prepares a will, he has to therefore incorporate the salient features of his will in the articles if he wants to bind the company. Now, a will is an ambulatory document because you can make a series of wills. You may make codicils revoking a past will and having a separate will. There is a concept of having a will on the deathbed. So you literally sign the final will when you're dying. Now, if you look at the principle of Rangaraj, those interim changes now become related parties. The first will, I had the voting power and I could therefore vote on my will to make it a part of the company. But as you progress downwards and there are other shareholders who come into being, the rule of SEBI is that the majority of the minority votes on this, and an interested voter has no vote. So the family gets ousted from the voting process and only the minority has a say. Now, when the minority looks at these kind of issues, the valuation rules, the separation rules, is the segregation in the interests of the family? Are they operating it in accordance with the principles of what they know, or are they hashing up the company in the sense people who are in management, are they getting displaced? So there are a host of considerations which affect the minority, and they are not the same as the family settlement, because the families normally settle on an equal basis and they choose the kind of undertaking that they want. So it is these things which bring in complexity. Therefore, the disclosure rule fails when you progress the family, and that's what breaks down this whole concept of, a binding settlement between the family members. So that's my view as such.
Thank you, Dr. Shroff. Homi, let's come to you. You may want to react to some of the propositions that Dr. Shroff focused on from a legal standpoint, and maybe you want to give your views from a corporate governance standpoint. But I just wanted to add one more element to it. Incorporating family constitutions now into the company charters, that has become a necessity. And I have come across many family constitutions which are very meticulously drafted. It records many aspects: devolution of wealth, vision, ethos, successive generations, how they are going to look at it, how do you resolve conflict. Though the most well-drafted legal agreements still land up in litigation. We've also come across situations where the meticulous drafting is carried forward as to, who's going to contribute what amount in case the family or the business needs more. Has this constitution ensured that the disputes are less, not just what we see so far, but likely to occur in the future? And the question is, do family constitutions need to be included in the company charter, and what has been your experiences from a governance standpoint?
I haven't come across this concept of incorporating in the articles, but I think it's a very good idea, because it certainly can sort of prevent nasty disagreements later. So I think it's an excellent idea. It's one of my takeaways from what Shardul was saying. And the other one is the separation of personal and company assets. I think that is also extremely important. But I'm not a legal person, so I was going to sort of talk about some of the difficulties faced by families generally, and what are the sort of good practices you can employ in non-legal situations to avoid conflicts later in settlements. So I was going to speak on those lines. So first of all, I think CEO succession is a very important item. Board refreshment, board succession is also a very important item, and very few companies really pay serious attention to it normally, till there's a sort of crisis, impending crisis. Somebody's getting old, somebody's on the verge of retiring, somebody wants to get out of the business, and that's when it comes up. So I was going to ask whether I could do a quick poll around the audience. So put up your hands. You're on various boards. How many of your boards really take succession seriously? Could I have, how many people would say that, hand on heart, I can say, my board takes this very seriously? Just a handful,
That's less than 15%, Homi.
Very few. And I think I've come across the same situation, most of the companies I've worked with. It's never been a sort of major item on the agenda, on the board agenda. And finally, the responsibility falls on the guy who's going to be the chairman of the NRC. I think that's the key role. The chairman of the NRC's duty is it to bring it to the board's attention. And if they're not doing it, at least put it before the board whenever he can, so that, it becomes part of the board agenda. It doesn't have to be at every meeting, it doesn't have to be every year, but at least every 2-3 years, at least think about, if there's a CEO who has to be replaced at some stage, there's a succession plan for him. If the board has to be refreshed, have a plan for that. So refreshing the board and having a succession plan for CEOs, I think, is a very important item, and the role clearly falls on the guy who's heading the NRC. And I've been in that situation a couple of times, and I know how important it is to try and bring it to the board's attention, because something which people feel uncomfortable talking about. Particularly in certain organizations that are family-owned, where the patriarch is a powerful person and, everybody around him are yes men and say yes to everything he says. But, it's the duty of the NRC guy, if he's on that board, to try and bring it onto the agenda and have an open and frank discussion on it. I think that's one of the key roles which I've had to play in various situations. I've been on the board of two family concerns. One had no intention of going public or being listed, so it was a different set of rules. And the other one was clearly a company which was trying to professionalize, already had gone public, and wanted to be projected as a professionally run company. So two different situations and different set of rules for each of them. But I think overall, keeping that balance between the non-executives, their views, they have the right share of voice at the board level, then you have a working situation. If you have sort of a disproportionate board and everyone is family members or friends of the proprietor's family, then you will never get that share of voice. So important to have an equal share of voice of both types of directors on the board. Some of the problems I've come across in boards which I've been on is, the chairman is very reluctant to ever give up his power. Very few chairmen sort of plan in advance. Yeah, I think I'm getting old now. I think somebody should be groomed to be my successor. They want to hold on till the last day. And most of them don't want to give up power. NRC has to therefore take that role and say, look, high time you discuss this item with your family members and bring it to the board, because someday this is going to happen. It could be a drop-dead situation, it could be a planned succession, but whatever it is, we should have some sort of a succession plan in place and agreement of the board before it happens. Because otherwise you're really walking into a trap where you'll have to finally go to legal experts and you'll try to solve it legally. But if you can avoid that and try and do a settlement before that situation arises, I think that's the best way of going about it. Sometimes it's best to even suggest roping in a professional consultant who can come in and talk to the board and say, look, this has to be done professionally. And that way, you're sort of also getting professional advice, not only relying on the advice of the NRC chairman. So that's another suggestion I would have. Meetings could be held outside the boardroom. I think that's very important, because having a family sort of council outside the boardroom is also a good practice. So the NRC chairman can sit with the family council outside of the boardroom and have open, frank discussions, because boards have to report what they're discussing. And in a family council, you can have a sort of informal discussion on a tricky subject and not bring it to a board before you're ready to take it to the full board. So I suggest, having a family council is a good idea. Options such as splitting, delisting, etc., have to be brought to the board. And of course, the idea of a charter of governance going to the articles is excellent. I fully support that. There's also this issue about when you're professionalizing, generally what happens is the chairman says, look, I'm the executive chairman. I'll have my sons or heirs or whatever as vice chairman under me, and they will run the company. But it's always advisable, if you're professionalizing and you're a listed company, to have a professional CEO under the vice chairman. A lot of people don't do that, and then they'll end up having to sort of play two roles: accountability to shareholders and accountability to his own proprietor, the father, or whoever is the patriarch of the family. I think if a board chairman is amenable to professional advice, make sure that the composition of the board is also brought before him. You can have one-to-one discussions with the chairman and say, look, let's have people on the board who will express a view openly. Most people want directors with whom they're going to be comfortable. And there has to be some discomfort if you want a good director on the board who's going to really make a difference. A little bit of discomfort is important. As one old friend of mine said to me, he's like, governance is like sleeping on a soft mattress. It hurts the next morning. So there is always a little bit of discomfort involved in governance, and it's good to have a guy who's outspoken and says a few things which may not be very popular, but they are hard facts and they have to be recognized. And finally, in any succession plan or planned succession which is going to be done, communication is extremely important. How you communicate with your staff, how you communicate with outsiders, what you do to handle difficult press situations. The moment they suspect something's happening in a company, you'll get lots of press reports. You have to be very active. You have to sort of respond quickly, correct incorrect impressions which are being floated around, and make sure that communications is taken very seriously during a period of change. So those are some of the thoughts I had on what you could do. One of the things I found very reassuring was there are settlements which have happened. I don't want to take names, but one which stands out is the Godrej settlement, where it never went to court. It was amicable. It was done quietly, privately, and the family is still very close, and I know the family, and there's no friction at all. They've sort of agreed to coexist in a particular way. And that's a lovely example, and I wish somebody write a case study on it, maybe a business school or somebody write a case study on that, because I think that's the right way to go about these things. When I talk to people in the families in these sort of situations, one of the things I always stress is, look, at the end of the day, family harmony is one of the greatest blessings in life. For God's sake, don't let wealth come into the picture. It's basically family harmony you guys should be thinking about. The moment the disharmony starts in a family, you're taking that slippery path and it's going to get worse and worse. So my advice to any family which is going to face this problem is put family harmony at the top of your list. And if you can work on those principles, then I think you have a good way forward. Okay?
It's interesting, Homi, you make a mention of the Godrej family. When I was doing my AI research in the morning, I figured out that this 19th century group was set up first to manufacture locks because there were too many robberies in the state of Bombay as at that point in time. And over the years, obviously, they diversified. 2-3 lessons that came since you mentioned Godrej, I'll take the liberty to talk about it. The family decided on what they call it as an ownership realignment, a term that was used and reflected thoughtfully in the entire group's restructuring. And they actually went ahead and defined that the objective of ownership realignment was business focus, governance, interestingly, it featured as one of the primary objectives, and generational priorities within the family. So with these three as the key objectives, the settlement, if you called it as a settlement, was executed very swiftly and amicably. I don't know, Dr. Shroff, if you would like to comment, since we breached our internal code of not mentioning any family name in this panel, we can talk about it.
I think this was one of those settlements where every detailed element of the settlement was a part of a scheme of arrangement. So effectively, they had their brand utilization, they had their non-competes, they had restrictive covenants, they had issues of royalty payments, they had issues of cross-border usage of the land which was in Godrej and Boyce by the Godrej main enterprise for the purpose of sales. So they had a very detailed agreement, and it was essentially to deal with the aspirations of the third generation. The third generation could have split, or the third generation could have lived harmoniously. So the elders of the family facilitated a settlement which was consistent with the third generation. That is the beauty of that settlement. And it went to court. So there's a wrong impression that, yes, schemes went to court, cross-holdings were eliminated as far as possible. So this is one scheme, and there is another group in the south which had a full disclosure and knocked out all the pyramids within the groups so that you have a linear organization. So eliminating all this is very important, and I think these are very good settlements.
Very good.
Dr. Shroff, though this separation or realignment of the ownership stands out as a good example of corporate governance from the point of view of preservation of minority interests, picking up the cue from what you said, I understand one of the reasons they had to go to the court and deal with the regulator was a nuanced issue in the SEBI law with regard to the takeover code. I know for a long time you have been advocating a separate law or flexibility on delisting in these forms of family settlement situations. Would you like to talk about that?
Yeah. So the reason why this is an important issue is that when the father started it, he had just one class of shares, his own. When the next generation came into being, the split happened in, if there are 2 members, 2, if there are 3 members, 3, and there was a separation in all companies. Now, when you say it's a realignment, basically you're saying that one enterprise has all the shares. So if it's person A, he gets the shares of B and C. If it's person B, he gets A and C, and with person C, you get A and B. That is the way you realign the shares. And that is the reason of the use of realignment in a family settlement. You had, just repeat your question.
My question was that you have been advocating a separate law to manage these family settlements.
I believe that this whole principle of doing demergers, amalgamations, all schemes of transfer are ultimately motivated by the principle that you have capital gains when you make an asset or undertaking transfers. So there are very strict rules governing the principles on which an exempt transfer takes place. So if you transfer all the assets and all the liabilities of an enterprise or an undertaking internally within the company and make a sub-company, then there is no capital gains tax. But if you make a mistake in that formulation, you would land up with full tax. So people are building their division effectively around this rule, and at times they are therefore crossing the Rubicon that you are transferring assets and not transferring undertakings. You have converted your personal asset into a corporate asset. You have allowed the people of the minority who are not family to have effectively a proportionate say in that company. You have brought in a concept where you're saying you have an interested voter. This concept is unknown to company law, but has been brought in by virtue of the SEBI law, that you can have a concept of a non-voting shareholder in a shareholders meeting. So if you see all the changes which have surrounded the process of actually division, either you do the division in true corporate interest, where supposing you want to separate out a particular undertaking because you're going to get a joint venture around that undertaking, then you start separating out those enterprises which are going to deal with the joint venture. But in a family settlement, the purpose is quite different. The purpose is essentially to secure the 2 families from not fighting or the 3 families from not fighting. They arrange it in a manner where they take the enterprise where they are familiar with the business. So what happens is effectively you're distorted the basic rule that a shareholder's property is distinct from the company's property. And that is a total distortion which has gone on because valuation gets tainted, the rules around which an undertaking is defined gets tainted, the enterprise balance sheet gets tinkered with. You don't disclose to the members of the public on a quarterly basis what is the undertaking. You do not have an asset register separating out the undertaking. So there is a lot of wrongdoing. I would say it's a nature of a wrongdoing. And SEBI has to think along the lines that, look, you need to have a separate regime for family settlements. You cannot have the normal regime of a professionally run organization where there is no cross-sharing of the shares. There is no, family-based division of the shares. It's basically continuing the shareholding as it was. So there is a need, because in India, 80% of the companies are effectively family-owned, and not counting the private companies. 80% of the listed companies have a family behind it. And if that is the rule, then you have to have, it's a huge population. 80 out of 100 is massive. So then you need to have a separate law where you deal with delisting, where you deal with amalgamation, where you discuss this alignment of shareholding, and you have a separate regime covering that. That's what I meant by saying you must have a separate regime.
Homi, coming back to the question of governance in the context of a family-owned business, it's one thing to say that the promoter family has majority shareholding, but it needs to be equally balanced with the minority and the institutional shareholders as well. In the Godrej cases and in some of the other cases as well, which hasn't gone in the right direction, what are the learnings from the Indian case study? I mean, at the end of the day, there are two other objectives which are competing, equally important. One between family values and governance.
Yeah.
Second, in many situations, if the family has tried their best to stay together, sometimes split allows independent growth and maintains the brand equity as well. And Godrej is a good example of that. So, but that's not necessarily true with other family settlements, and we've seen other family settlements resulting in washing dirty linen in the public.
Correct.
What are your experiences, and what, in your view, are the good governance practices?
A lot of it depends on the sort of culture and the value systems in that organization, and what the proprietors have brought with them as their corporate culture. Obviously, you would like to, have no mud splashed in public, and they have handled that part of the thing. Usually, it's done through professional communication, better communications, but it can happen because if some member of the family talks to the press, it becomes messy. So I think the corporate value which the brand brings with it is very important. And preserving that is something which the board must realize is very important to the future of the business. Whoever's going to run it, even if it's a split business, or holding company, subsidiary company, delisted company, you still want to preserve that brand image. So work has to be done in that area, and expert communications therefore are needed at a time like this. This is what point I made, that you need a professional communications expert to guide you through this phase, because there will be external criticism, there will be external inquisitiveness of what's happening, what they read in the press. Somebody writes a bad report and it becomes like gospel. That's the way it's going.
And because it's a public process, you have your competitors bringing you down.
Yeah, competitors can really play up the thing also. So there are lots of issues involved in these situations.
Okay.
But I think corporate values makes a huge difference. Now, you're talking about Godrej, for instance, one of the things which always impressed me about Godrej is, for years, everybody eats together in their canteens. Staff, officers, everyone. There's no separate canteen for workmen, separate canteen for officers. That's the sort of culture the organization has. Total avoidance of opulence. Nobody in the family sort of brags about, their personal wealth, or goes around in flashy cars or anything like that. Very simple family. They were very Gandhian in the old days. Most of them are vegetarians, despite being Parsis, which is quite rare. But, this is sort of family culture which brings people together and keeps them together at a time like this.
So the culture which Homi just mentioned in the first round is family harmony must trump everything.
That's the most important.
Okay, so let's throw the floor open for discussion. I don't know how much time we have, but Mr. Damodaran is sitting in front of me. He will just signal me, close the session, because you're standing in the middle of lunch. He's already signaled that. But we will take a couple of questions with your permission, sir.
Yeah.
Yeah. Why don't you go first? Just mic over here.
Mic.
So in some companies, hopefully not too many, you have the old promoter who doesn't want to step out. He wants to continue, the point that you mentioned. And it's very difficult to persuade old promoters, right? I'm old, I'm not a promoter, but I can sense where the resistance is coming from. So one of the things that we did as external advisors, because the rest of the board, they threw up their hands, they said, can you help us? So what we did was, I had a long chat with the gentleman over 2-3 sessions of excellent tea and biscuits. And I told him that you've done so much. You have to be a chairman emeritus. And the only way you can be a chairman emeritus is it has to be given to you in your lifetime. Therefore, why don't you step down from the board and allow the board and the stakeholders to recognize you for your contribution? Make you a chairman emeritus. Somehow that seemed to have clicked. And he negotiated with his family members. You make me chairman emeritus at the next meeting, I will step down, and he did. So there are ways and ways.
But sir, there is a gap in this structure. A chairman, if he's an executive chairman, is entitled to full remuneration.
Correct, yeah.
When a person shifts from a chairman to a chairman emeritus,
He
he loses his remuneration.
Yeah, that's a climb down, but you got to persuade them that what's the trade-off? You know, getting less money for a couple of years before God sends you a ticket, or whether you want to hold on to your position and be denied the opportunity of becoming a chairman emeritus.
Just on a humorous note, this happened in a club where I said, why don't you become a chairman emeritus? And the first circle he put out was chairman emeritus.
Any other questions or observations? Okay, before we end the session, I think Dr. Shroff, you are absolutely correct. The latest study does say that the family-owned businesses contribute 80 to 85% to India's GDP. I just thought I'll take the liberty to ask one more legal question. Again, a very important Supreme Court judgment, Ranganath Reddy's case, which gave a very wide ambit to, in the context of family litigation, and it says that you need to construe the term family very, very broadly. Unfortunately, neither the SEBI law nor the income tax law is as broad, but the Supreme Court in this case gave a view. You think that the future of the regulations, the change that you spoke about, can be navigated to afford more such settlements and not become a prisoner of the various regulations that we have?
See, the basic rule of formulating all these family settlement structures is that there must be an undertaking. You are not transferring assets, you are not transferring individual liabilities, you are transferring the whole bunch of assets and you are transferring the whole bunch of liabilities. If the SEBI lives with this structure and you're able to convince them that it is the entire enterprise, there is nothing left out, then in the period between 76 and early 90s, the rule of Kale's judgment, which is the Reddy judgment that you mentioned, was enforced to include non-family members, people who had a beneficiary stake in it, people who were completely unconcerned with the true concept of what is a family. Family was extended to companies. So it was implemented for 20 years. Then SEBI got wiser. They said, you are not a member of this family. Show me how you are a member of the family. Show me how you're cross-connected as promoters. So the split process happened in the post-90 era.
Thank you. So before there's one question. Can you make it quick, please?
Lots of families, in order to regulate their affairs better, have been going into the process of family offices. Recently, very recently, it's come in some section of media, I've been reporting that regulators now want to regulate family offices.
Yes.
Do you think that's a case to do that, or is there over-regulation?
No, I think what has happened is that family offices today have migrated from India. They're sitting in Dubai, they're sitting in Singapore, they're sitting in Greece, Cyprus, England. So they are not, the base, 80% of the family offices are outside. So the 20% offices which have resided in India do need a regulation because they have different species of assets. They've got art, they've got shares, they've got immovable property, they've got jewelry. So basically the family office deals with these kind of estate, which is basically transfer. Now in a trust, there is no concept of a transfer. You have described the beneficiary in a very wide way. So you enable succession to happen without really charging every event of a successor coming to a tax. And that is why it is efficient over a actual vesting in a natural person. So that's the trick behind a family office, that a trust is not recognized as an event of succession, as an estate duty event. So the whole family office is built around this particular structure, and it is put into zones where taxes are very low by design or by no tax being there in relation to these particular structures. Now, it requires a bilateral agreement between two countries to abolish that. So if India and Dubai entered into an agreement, we don't want family offices, the whole family office structure will collapse. So also with Singapore, so also with Cyprus. Any of the countries which tolerate this as a means to avoid estate duty. There is no estate duty, but there is anticipation that ultimately estate duty will come. It is there in all, developed countries. And if India is on the route to being a developed country, the question will arise in the future. The reason why estate duty got abolished in India was that the cost of administration and the kind of questions which people raised had more cost than the estate itself. So it was counterproductive, because in the process of controlling those costs, the trusts, or controlling the estate duty estate as such, if I am spending more than what I am getting in, I would have to stop. And this is VP Singh's judgment in the parliament, that I don't want this because my analysis shows that the cost is more than the estate that comes in. But it's a great equalization tool. You effectively tell the second generation that you're only going to get 50 or 60% of your property saved by your ancestors. And the rest of it goes into public domain. So you don't have major monopolies of power and wealth sitting with a family. You break up all these kind of monopolies that exist.
In my final CA exams in November 95, I had to go through the estate duty paper, which was most complex, despite the fact that in March earlier that year, estate duty was abolished by VP Singh, because India collected 225 crores in estate duty and the cost of administration was 257 crores. Let me end the panel on a note. This is a very famous quote by Professor William O'Hara. It says, before the multinational corporations, there were family businesses. Before the Industrial Revolution, there were family businesses. Before the enlightenment of the Greece and the empire of Rome, there was family business. So on that note, let me thank my esteemed panel. Dr. Shroff, Homi, thank you very much.
Thank you.
Please join me.
So thank you, Mr. Khusrokhan, Mr. Butani, and Dr. Shroff for giving us such deep insights into the topic. Ladies and gentlemen, can we give them a big hand? And with that, may I now request Mr. Damodaran to please present a memento to each panelist. On behalf of each panelist, Excellence Enablers is proud to have sponsored Education for One Girl Child, for 1 full year through the NGO Nanni Kali, a Mahindra initiative. So thank you, Mr. Damodaran, for doing the honors.